Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And I hope everyone has a Merry Christmas. Made this video at the last second, thinking that this might be helpful to a lot of people. So let's get into it. Okay, so today we're going to talk about trusts, pro se lawsuits, and the unauthorized practice of law, TRAP, which is a problem for a lot of people. And you need to know ahead of time what to do, what not to do, so you don't get in this trap. So if your home is titled in a trust and you file a lawsuit as trustee without a licensed attorney, courts often treat that as practicing law without a license. Courts consistently hold that when a trustee files suit for a trust without a lawyer, the trustee is practicing law without a license because they are representing a separate legal entity. Even if you created the trust, you are the trustee, you are the beneficiary, and it's your primary residence. The trust, not you, owns the property. So when you sue on behalf of the trust, you are representing a separate legal entity and not yourself. Courts routinely hold that a non-lawyer trustee cannot represent a trust in court, and doing so constitutes the unauthorized practice of law. What usually happens is this: the judge orders you to hire an attorney, or the case is stayed, or the case is dismissed without prejudice before the court ever looks at your evidence. This happens quite often in quiet title and foreclosure cases because judges will not allow non-lawyers to permanently affect land records on behalf of a trust. So the bottom line is, if you want to proceed pro se, the property generally must be in your individual name and not in a trust. Otherwise, the trust must be represented by a licensed attorney. So there is case law to back this stuff up, guys. The first case is C.E. Pope Equity Trust versus United States, and here's the case information here. You can look it up. What happened? The trustee of a trust filed a lawsuit pro se, arguing he could represent the trust because he controlled it and was closely connected to it. What the court held? The court flatly rejected that argument and held that a non-lawyer trustee may not represent a trust in court. The key reasoning was the trustee was not representing himself. He was representing the trust's legal interests, which constitutes the practice of law. Because he was not a licensed attorney, the filings were improper. And courts use this case and cite it. This is the leading case establishing that when a trustee appears pro se for the trust, it is treated as unauthorized practice of law, regardless of the trustee's personal connection to the trust. There is another case called Knopfler versus United Bank of Bismarck, and this one was from 1994. What happened in this case was a non-lawyer trustees attempted to prosecute claims on behalf of a trust without an attorney. What the court had held on this case was the Eighth Circuit held that non-lawyer trustees have no right to represent a trust in court. The key reasoning behind this: a trust is a separate legal entity, and representing it requires a licensed attorney. Acting otherwise is impermissible, and the court will not allow the case to proceed. And why it matters especially? This case is binding precedent in the Eighth Circuit and is frequently cited to enforce the rule that trustees acting in pro se are engaging in unauthorized legal representation. The legitimate reasons, the good ones. So when is it okay or good to put your house in a trust? Probate avoidance is the primary reason. This is the number one reason revokable trust exists. It avoids having to go to probate after someone dies. It allows heirs to transfer or sell the home without court, and it saves time and some court fees. The key point to this is this benefit applies only after the homeowner dies. Continuity if incapacitated. So if the homeowner becomes incapacitated, the successor trustee can manage or sell the property. No guardianship or conservatorship is needed. Again, this is about management, not protection. So in estate planning and heirs, trusts can handle multiple heirs, avoid probate in multiple states, provide instructions for distribution. This is useful for families, not litigation. Okay, so what revocable trusts do not do, these are the myths, guys. They do not stop foreclosure. Lenders can foreclose on trust-owned property. Courts treat the borrower and trust as the same for debt. Mortgage obligations remain fully enforceable. They do not protect from creditors. Revocable trusts offer zero asset protection. Judgment liens, IRS, all attach anyway. Courts view revocable trusts as alter egos of the owner. They do not give you special court privileges. This is a big misunderstanding. Trust ownership removes your right to appear pro se, forces attorney representation, and creates procedural barriers. In court, trusts reduce access. They don't increase it. Why so many people are told to use them anyway? This is a good question. Estate planners don't litigate foreclosures. Estate attorneys focus on death, probate, incapacity. They do not warn clients about foreclosure litigation, quiet title actions, or pro se limitations. Those are different legal worlds. So, title companies and realtors use boilerplate. Sometimes trusts are used because title companies prefer them, realtors suggest them, forms are standard, but nobody explains the downstream consequences. So, there's also a lot of internet and seminar misinformation out there. People are told banks can't foreclose on trusts, MERS can't touch trusts, courts recognize trust sovereignty. None of that is true. Confusion with irrevocable trust. Here's another thing you should know. Many people confuse revocable trust with no protection with irrevocable trust with limited protection but has strict rules. They are not the same. Why trusts often backfire in foreclosure litigation. When foreclosure or quiet title litigation arises, standing problems appear, attorney requirements kick in, cases stall or get dismissed, defendants gain leverage, the trust becomes a procedural roadblock. When a revocable trust does make sense for a home, it's because you have clear estate plans, multiple heirs, out-of-state property, no anticipated litigation, willingness to hire counsel if litigation arises. When it does not make sense, active foreclosure, planned pro se litigation, quiet title actions, a need for court access without a lawyer, then it does not make sense. The big picture, the difference, a revocable trust is treated as you. An irrevocable trust is treated as not you. Revocable trust, what homeowners have. This is what most people have. What revocable means, you can change it. You can cancel it. You can move property in and out. You keep full control. Because you keep control, the law treats the trust as your alter ego. Now, what's that mean? If you have already put your house in a trust and you plan on suing your lender and filing a quiet title action, you can also take it out of the trust and put it back in your name before going to litigation so that you don't have these problems. Okay? How courts see a revocable trust? You equals the trust. Trust access equals your assets. Trust debt equal your debts. So for legal purposes, creditors can reach it. Lenders can foreclose, IRS can attach it, and courts ignore it as a shield. So, what revocable trusts are good for? Avoiding probate, managing property if you come incapacitated, estate planning for heirs, administrative convenience, and then what revocable trusts are not good for is asset protection, stopping foreclosure, shielding from lawsuits, pro se litigation access, and critically, if you sue as trustee, courts say you are representing a separate entity, which triggers the unauthorized practice of law problem. And the irrevocable trust is a very different creature, guys. What an irrevocable trust means, you generally cannot change it. So if you put your house in an irrevocable trust, you cannot get it back out. You cannot revoke it or change it. You give up control. You often give up ownership. This loss of control is what gives it legal power. How courts see an irrevocable trust? The trust equals a separate legal entity. Assets are no longer yours. Creditors may be limited or barred. Estate tax and Medicaid planning may apply, but that separation cuts both ways. What irrevocable trust can do? Some asset protection, Medicaid planning with strict rules, estate tax planning, creditor insulation sometimes. What irrevocable trust cannot do is let you control the property freely, let you sell or refinance easily, let you litigate pro se, let you take property back without consequences. And importantly, you still cannot represent it pro se. It always requires an attorney in court. And why irrevocable trusts are rare for primary homes? For most people, giving up control of your home is unrealistic. Refinancing becomes difficult or impossible. Mistakes are permanent. Foreclosure issues become more complex, not less. That's why most homes are in revocable trusts, not irrevocable ones. And why people get confused. People hear, trusts protect assets. Trusts stop creditors. Trusts block foreclosure. Those statements are sometimes true, however, only for irrevocable trusts and only if it's done years in advance, structured properly, not self-settled in prohibited ways, is compliant with state and federal law, and that is not what most homeowners have. So remember, a revocable trust is what happens after you die, not what happens when you're sued or foreclosed on. And irrevocable trusts do not stop foreclosure. A mortgage lien still follows the property. What irrevocable trusts sometimes affect is creditors' access and personal liability, not a lender's right to foreclose on a valid deed of trust. Okay, guys, that's it for this weekly foreclosure presentation. I hope this was informative for a lot of people. This is my private Facebook group, which you can join. It's on. It's called Foreclosure Help 777. And if you have a question about your own foreclosure, you can send me an email. My email address is foreclosurehelp777@gmail.com. So I hope everyone has a Merry Christmas and a Happy New Year. And we'll talk soon, guys. God bless.